more difficult for the court to adjudicate than the constitutional standard of adequacy. And that's because in both instances, the court must determine what the standard is. But whereas in the case of adequacy, or equity, as this court held in Horton 3, the constitutional standard is at what point disparities in educational opportunities are so great as to emasculate the purposes of substantial equality. Similarly, in CCJEF, the court found at what point do disparities in ethnic and racial isolation emasculate the principle of substantial equality. Now, the term emasculate the principle of substantial equality seems to be a fairly nebulous one, but nonetheless, the court in both cases found that it was within its powers and that it was capable to adjudicate this constitutional standard. With respect to the constitutional standard, in our case, an adequacy standard, there are many reference points this court can look to. Indeed, as I mentioned, there's broad consensus among all three branches of government of what the constitutional purposes of education are. And to the extent that this court has concrete guideposts that it can look to.
I grant you slope to be on, but I believe firmly that when you're second guessing, as the plaintiffs are, the level of funding and the programmatic choices that are being made by the legislature or by local boards, you are clearly on the side of simply assessing quality. And that is not what the Constitution of 1965 was about. And if I might,
Mr. George, can I just interject for one quick? Back to the equality issue for a second. And I would like your view on what exactly it is that CCJEF means in terms of, and its predecessors on equal educational opportunity. The school children, I presume that you're not suggesting that because Greenwich has a particular mode of education or caliber of education for its students, that every other town in the state is entitled to that level of education, or do you?
No, I don't, and I'm not sure that this court's jurisprudence has fleshed out exactly what a substantially equal educational opportunity will mean.
I guess I don't mean to belabor this, but because it's not simply comparing one district with another, there's got to be a substantive component to that comparison. There's got to be some determination. It's not just taking towns 1, 2, and 3 and looking to see what sort of education they're providing their students, right, and determining whether towns 3, 4, 5, and 6 are providing their students with that education. There's got to be a substantive component to it.
There needs to be some sort of substantive measure, but not as a constitutional floor or a constitutional qualitative minimum. It will be difficult, no doubt, to determine what the proper comparators should be. I mean, the court in Horton said it may well be, because there were going to be further proceedings, it may well be that additional hearings will help sharpen the difficult substantive judgments that will have to be made to make those comparisons Chief Justice Peters was talking about. Yes, but that's as a matter of equality. This is not...
That's as a matter of what?
Equality. Equality. As an equal protection case, do kids in different towns or anywhere in the state enjoy equal protection, equal educational opportunities?
It's hard for me to see how that test does not have a substantive component. I agree with you. Determining what precisely that substance is maybe very difficult. Oh. But it does seem to me that it implicates certain substantive rights that students have.
Substantive rights, I'd argue with you, Your Honor, but substantive judgments for purposes of comparison, absolutely. I mean, I haven't done this very well, obviously, in distinguishing between not only equality cases, but common law.
That case has been in litigation for a dozen years, so you're not to blame for any, difficulty in
it's only me up here, Your Honor.
About. Pardon me?
It's only me up here. This is not an equal, this claim of a constitutional floor, suitable, minimally adequate, what have you, is not the same as an equal protection case. It's not the same as a standard of care case, a malpractice case of some sort.
I understand. I'm just wondering whether there is such a sharp difference in terms of the justiciability of one and the justiciability of the other, that's all.
It's because of the constitutional nature of the standard that you're trying to use. In a malpractice case, let's say it's an education malpractice case, it would be very difficult to determine what the standard of care is for a school system. Let's say such a tort existed. But you'd have experts come in and try to convince the court as a common law matter that there is a standard of care and it was breached. Fine. Equal protection, same thing, as a comparator. As an administrative matter, what is a suitable education? Difficult term to define. Experts would come in, the Board of Education would use its judgment and expertise in determining what that means. The court might review it on appeal. But as a constitutional matter, very different in saying that we are going to engraft onto the Constitution a standard of suitableness, adequacy, minimal adequacy. And make no mistake, that is what the plaintiffs ask. That's what paragraph 46 and 53 of their complaint argues, is that all of these inputs are necessary to a suitable education in and of itself, not as a comparator, in and of itself. And that exercise is not borne out by the text or the history of this state, text of our Constitution or the history of this state. In fact, going back to the plaintiffs rely on the Ludlow Code. Well, the Ludlow Code's allusion to a good education, which Judge Bernstein uses a few times at the 1965 convention, was a duty imposed on parents. Good education is found in a whereas clause in the Ludlow Code over nearly 400 years ago, telling parents that they have to educate their kids. Nothing in the Ludlow Code made it an obligation of the state to educate the kids to a certain standard, or certainly that it would be judicially enforceable. So when you come later to Bissell versus Davison, a case that the plaintiffs use to claim that there's a state duty to educate their children, certainly there's a state duty. It was at common law before the Constitution. But Bissell versus Davison goes on a paragraph or so later from what the plaintiffs cite to say, the question what terms, conditions, and restrictions will best subserve the end sought in the establishment and maintenance of public schools is a question solely for the legislature and not for the courts. That's our history. That's this court's history. Judge Bernstein himself goes to the 1965 convention and says the purpose of the education article, and this is at page 312 of the proceedings, which we provided by letter. The purpose was to establish and place in our Constitution provision for free public school education subject